And I'd ask the city attorney to respond to the issues and advise the council.
Our office recognized the importance of this issue to the community, and we asked four attorneys in our office to independently review these notice requirements and whether or not those requirements had been met. We reviewed the case law, and the case law interprets this provision of the Street and Highways Code very liberally, such that noticing that is in substantial compliance or in whole or the totality of the circumstances meets the noticing requirements has generally been upheld and will not be overturned for inadequate noticing.
Ms. Fry.
Thank you. In the Streets and Highways Code, at least what's been provided to me, and maybe I'm not reading this correctly, it says that that the notice of the hearings on the proposed vacation shall be published for at least 2 successive weeks prior to the hearing in a daily, semi-weekly, or weekly newspaper published and circulated in the local agency conducting the proceeding and which is selected by the legislative body for that purpose or by the clerk or other officer responsible, etc., etc. At least the information I have in front of me for the continuance request, or basically the defective noticing, I guess would be the best way to put it, says that there was no advertisement provided for 2 consecutive weeks. So, if maybe staff can comment on that.
Dan Stricker, Development Services. On November 14th, the notice of the City Council hearing for today's date was mailed to all the people that live within 300 feet, and it was published in the San Diego Daily Transcript for this hearing today, and it included the public right-of-way vacation.
Twice. Is that correct?
That is not the way I interpret it. It was not put in twice. It was put in on November 14th.
Okay, well, let me just read you this and see how we interpret it again. It seems... Notice of the hearing on the proposed vacation shall be published for at least 2 successive weeks prior to the hearing in a daily, semi-weekly, or weekly newspaper published and circulated in the local agency conducting the proceeding and which is selected by the legislative body for that purpose or by the clerk or other officer responsible for the publication where the legislative body has not selected any newspaper for that purpose. So I guess my question is...
It's my understanding it was published once, and that was published on November 14th.
Okay. And so I guess that's what seems defective to me, that if in fact that there is a requirement by the California Streets and Highways Code that notice be published in some sort of a newspaper for 2 successive weeks, and if that in fact did not occur, that you probably would have a defective notice, unless there's something I'm not understanding. And so because of that, it seems that there shouldn't be a continuance to Friday, that there should be, for the vacation and for this hearing, that at a minimum, to be on the safe side, you would re-notice it. In other words, you would take the 2 weeks, you would cure and correct whatever the problem was, and then when you had the hearing, the issue would not be a problem. I'm afraid that the simple solution here might not be followed. I think it's a pretty simple solution. And if it is, it would probably save the city litigation, probably save the applicant litigation. I expect that there will be litigation. And again, I don't base my decisions on whether or not we'll be sued, because we're sued all the time. But I do sort of look at the plain language that's in front of me, and if it says 2, then my guess is it means 2. And if you don't have 2 and you were supposed to have 2, it doesn't seem that tough to, it doesn't seem that difficult to, like you said, unless I don't understand it. So anyways, that would be my thinking on it, that it needs to be returned. It needs to be properly, just do it right. If it needs to, then give it two. Post the darn notice, give it two successive weeks in a newspaper, and come back, which should be, come back in January. And I think that's a fair solution. So my hope would be that we don't do this continuance, because I think we're just going to cause a whole lot of problems here.
Can I say? Okay, I just wanted to bring to the council's attention, I was asked to research the posting issue as the deficiency in this circumstance. I had been told that the publication issue had been addressed. I had not been told that staff had interpreted the code as requiring one. I would ask that the item be continued and that I have these 3 days in order to research this issue to find out whether or not one publication would be sufficient to substantially meet the requirement, given that the notice requirement has been met in every other aspect of this item, or ask that the item be returned, whatever is the council's preference.
Well, it would be my preference, again, just from the plain language reading and the fact that staff has said that they didn't do it. It says 2, they did 1. Whether that's the way they've always done it in the past doesn't mean that that's correct. And so to avoid a Friday, very long hearing potentially, where we're going to be talking about something that, again, to me, certain things that one reads, and it says, notice of the hearing on the proposed vacation shall be published for at least 2 successive weeks. I don't know how much simpler it can be, Mr.
I think you raised an excellent question, and my suggestion, Ms. Fry, would be that would be the first issue that's talked about on Friday. But the city attorney's asked for some additional time to look at that.
But can I ask you something? If it's not properly noticed, right? Then why are we scheduling the meeting for Friday?
Well,
because we're going to lug a bunch of people in.
Obviously, we're not going to go forward if it's not properly noticed. What the city attorney's asked for is the additional time to look at the issue you've raised.
Right, and when they come back with that, like I said, I guess I don't see the big rush to Friday.
Well, the reason is that we've been working on this issue since before I was elected, and it would be it's something that I don't think would be fair to turn over if we can deal with it while we're here. Because
I don't think it'd be fair to hold the hearing on Friday when I don't think it's been properly noticed, and I think it's a fairly simple issue.
Okay. There's a motion by Mr. Adaffer, seconded by Mr. Hueso, to continue to Friday. Please vote. Call the roll. Passes 6-2 with districts 4 and 6 voting no.